All right, ladies and gentlemen, this is the monthly meeting of the Cobb County Board of Zoning Appeals. We are here today to hear a special appeals case. And as our procedure follows, I'm going to introduce Miss Deborah Dance. Deborah Dance has been selected to be the moderator of this procedure today. And with that said, Deborah, I'm going to turn it over to you, and you explain the ground rules, and then we'll proceed from there.
Yes, I will. We are here today on an appeal that was filed on April 24th, 2015 by appellants Dinkins, Proctor, Galanek, and Kelly. It was also amended on May 1st, 2015 by Proctor and Dinkins. The appeal is filed pursuant to Cobb Code Section 134-95, and I understand that a motion to dismiss has been filed. I don't know if any other procedural motions have been filed, but the first order of business would be for the board to hear the procedural motion, which is a motion to dismiss. If after that motion is heard, it is the decision of the board that the hearing is to proceed, then one representative of each side would come forward and make what is called an opening statement at the podium, and I'd ask you to designate one individual in order to do that. That will be a 3-minute presentation. Each side will have 20 minutes total for the presentation of evidence and argument. The first, since the individuals bringing the appeal have the burden, they would come forward first and state the grounds on which they have brought their appeal and present any evidence, testimony, documents for consideration by the board. Thereafter, the board, its members may ask questions. Those would not be counted against the side at the time the questions are asked. The county would then present its case and with the same ground rules. Each party would then, at the conclusion of the presentations, each party would then have opportunity for a summation, the summation lasting 3 minutes. And those are the rules that we will follow.
Okay, at this time, I see Mr. Proctor has a question. Do you have a question for this body? Yeah, anything that you're going to ask, I need you to come up front to the podium. And again, for the purpose of the record, I'm going to ask you to give us your name first and then ask your question.
My name is William E. Proctor, 3727 Wilkins Circle, Powder Springs.
Your question.
My question, when I started this appeal and I asked questions, I was informed by the clerk's office that we would have 10 minutes and the respondent would have 10 minutes, and then there could be some argument back and forth. And now we're talking 20 minutes, and I haven't prepared 20 minutes, and I could probably have done so, but I thought there was a 10-minute limit. So, I mean, someone from the office, and I've got an email at home, it's not with me, stating that we each had 10 minutes, which would be the same as the Planning Commission when we argued this thing before. So that concerns me.
Okay, well, let's stop right there. Now, Debbie, the hearing officer, let's address that question.
I determined that 20 minutes is reasonable. Based upon what I've watched and observed, people often go over. There are often matters that are considered that people don't consider before they get up there. In fairness, I think adding an additional 10 minutes does not prejudice anyone, but allows you an opportunity to make sure that you get your full side out.
Well, I disagree because, I am not an attorney and my attorney isn't here, and I prepared my statement with his help, and so I just happen to disagree with that.
And that's okay. Also understand that this board has the latitude to either add minutes, take minutes away. So we want to make sure it's a fair hearing, that everybody has equal opportunity to present their case.
I understand.
So as we go through this, I think you'll find that we will either add or take away, but we'll make sure everybody is compensated.
Well, I'm just
the
concerned that if I prepared a 10-minute talk.
And 10 minutes is all you may need. That's no problem.
But if my opposition is prepared 20 minutes and argues more things that I feel like I'm at a disadvantage.
Okay, well, before we get into that, I see your opposition is here. If you would please identify yourself, please.
Hi, my name is Debbie Blair, and I'm representing John Peterson for the county. My presentation is probably about 10 minutes as well, so
Good deal.
we're on the same
We're on
page.
target.
We've compromised already. That's very good. Now we'll start off. All right, Ms. Dance, I think we got that out of the way, and we cleared it up pretty good. So with that said, you may continue.
Okay, as I am aware, there is a motion to dismiss appeal that has been filed by Ms. Blair. Are there any motions that you desire to bring on behalf of the appellants? These would be motions that are in advance of the hearing.
No, I just like, do I get a chance to?
Yes. So I would ask Ms. Blair to come forward, and let's limit the testimony on this issue to 5 minutes per side.
And this is just to dismiss.
That's correct.
Okay, ma'am, go right ahead.
Again, I'm Debbie Blair representing John Peterson. If you would key that. I have a motion to dismiss the appeal, but first I want to tender into the record my motion to dismiss as well as my position brief and its accompanying exhibits, and I'm going to read those into the record just so that it's clear. I'm tendering the following sections of the Cobb County Code: 50-216, 134-94, 134-95, 134-121, 134-162, 134-164, and 134-193. I'm also tendering Cobb County meeting minutes for the December 2nd Planning Commission meeting, the December 16th Board of Commissioners zoning meeting, the March 10th and the May 12th, 2015 Board of Commissioners regular meeting minutes. As well, I'm tendering the following documents: the West Cobb Sports Complex application for the special land use permit, staff's recommendations of SLUP 19, the certification of zoning dated December 31st, 2014, and the submitted survey, the site plan application for clearing only, the appeal from the appellates dated April 24th, the amendment of the appeal dated May 1st, 2015, as well as a portion of the zoning map which reflects the subject property as well as some of the surrounding areas. The other document that I'm tendering is an affidavit by John Peterson, and copies of all of these documents have been provided to the board as well as to the appellants.
Do the appellants have any objections to the tender of these documents? Okay, they shall, upon the board's acceptance, they'll be deemed admitted.
Okay, do we need a vote on that? No. Or just our consensus is that we accept the information provided for us that Ms. Blair has just talked about, and it's in
That's
these.
correct.
These are the documents.
Yes.
And we all have a copy of these documents, is that correct? Okay, so we accept that.
As I go through this portion of my presentation, it's very date intensive, so I have prepared a list of the dates that are applicable to this, and it's up on the monitor for your reference. It is Cobb's position with respect to this appeal that it should be dismissed in its entirety. As I will explain, this position is fully supported by law. This appeal should be dismissed for the following two reasons. First, it was untimely, meaning it was not submitted within 30 days of the decision that is being appealed. And second, while the appellates contend that the clearing-only permit should have been placed under the private parks moratorium of March 2015, this moratorium is now lifted, and therefore it's of no force and consequence. Regarding the untimely appeal, the appellants disagree with the issuance of the certification of zoning by John Peterson on December 31st, 2014. The Cobb County Code, section 134-95, states that any person aggrieved by a zoning or by a decision of an administrative officer may file an appeal with this board. That appeal must be filed within 30 days of the decision. The appellants filed their appeal on April 24th, 2015, almost 4 full months after the date of the certification of zoning. This appeal is untimely and should be dismissed. Appellants also challenge the decision of staff to accept the clearing-only application, saying that it should have been under the private parks moratorium. That application was filed with Community Development on February 24th. That appeal was also filed as part of the April 24th appeal, almost 2 months after the Community Development accepted the clearing-only permit. Applicants' claims are time-barred and cannot be considered. Likewise, appellant's amended appeal is also time-barred. Georgia courts have consistently held that actions challenging a zoning decision are time-barred if that appeal is not received within 30 days of the decision. That case site is Village Centers, Inc., v. DeKalb County, 248 Georgia, 177. Further, the timely filing of a notice of appeals is an absolute requirement to confer jurisdiction upon the deciding body. The deciding body here, you, the BZA, has no authority to hear the case because the appeal was not filed within 30 days of the decision. And that case site is Hester v. State, 242 Georgia, 173. In regard to the second issue, the moratorium is now expired and any issues regarding the moratorium are now moot. Appellants contend that the clearing-only permit should not have been accepted because of that moratorium. However, the clearing-only permit application was submitted to Community Development on February 24th. The moratorium went into effect on March 10th, after Community Development accepted the application. The moratorium was then lifted on May 12th. Now that the moratorium has expired, there is no longer an actual controversy and nothing is to be decided. That case site is R.G. Clark v. City of Atlanta, 291 Georgia, 84. Appellant's argument that the property should fall under the moratorium must fail because the moratorium is no longer in effect. Furthermore, even if the moratorium had not been lifted, the plain language of the moratorium provided that staff was to suspend the acceptance of applications for private parks. Because this permit was submitted on February 24th prior to the moratorium, it would not have fallen under the moratorium even if the moratorium had still been in place. Therefore, due to the untimeliness of the application and the fact that the moratorium is no longer in effect, this appeal should be dismissed in its entirety. Thank you.
Okay. I do have a question, if I can ask a question. Were all these upheld by courts? All the cases that you have,
All the cases that I've cited are good law.
and they have been all upheld throughout the court system?
That's correct.
That's correct. That answers my question. All right, Deborah, back to you.
If I can have the appellants come forward.
William Proctor. I just received the notice of this motion to dismiss, and I guess I felt it strange that when a certificate of zoning, there's no notification required. So I just, first of all, how in the world is someone supposed to know about something that's in place when there's no notification to any of the adjacent property holders? But withholding that, I noticed on the appeals of administrative decisions on section 33, it says the appellant has 30 days from the final decision offered by the administration, the final decision. So does that mean the decision when the first certification was given? And I quote an email. I had a meeting with Commissioner Ott prior to in early April, because I was basically frustrated because I couldn't get any answers on any of the projects that was going on. And I asked him, what can I do? I said, I have no voice in this. And Bob said, he said, well, you do. You can send an appeal. So I wrote him a email on April the 1st, 2015. I said, Bob, thanks for meeting me yesterday on such short notice and providing information that I have a voice. Please confirm that you will arrange a meeting for me with Rob Hosack and John Peterson to discuss their decision to grant a certificate of zoning for the West Cobb Sports Complex plus other issues. Also, please confirm that if I'm not satisfied with the answers I receive, I will have 30 days to appeal their decision with the Board of Zoning Appeals. Thanks, Bill Proctor. Response from Mr. Commissioner Ott the same day. Bill, you are correct on both. I am copying Rob with this email. He will reach out to you. He will also explain the appeal process to you. Subsequent to that email, I had a meeting with Mr. Peterson, Mr. Hosack, and we discussed the issues, and we determined probably at that time that the county was not going to budge on their decision on what to do, and we discussed my appeal process. So I argued the fact that the final decision on this appeal process was not granted until April the 2nd when we had our meeting with Mr. Hosack and Mr. Peterson. And as far as in going to the moratorium being moved, I tend to disagree with that. I mean, I'll read you what I have is my objection. It's like the administrative decision paves the way for the development of a private park in violation of the suspension of the Board of Commissioners of the acceptance of application for rezoning permits, permits for construction, permits for land disturbance, business licenses at any private parks, the one that was adopted, March the 10th. The site plan review application filed by West Cobb Athletics, Inc. and John Varner for the proposed West Cobb Sports Complex development at issue in the administrative decision was not complete as of the moratorium enacted by the Board of Commissioners on private parks. Prior to the moratorium, this application did not include the required hydrology study, owner acknowledgement, proof of valid business license, erosion and sediment control plans, notice of intent, delineation of soil series, grading plans, and also it did not have the required filing fee. So we're arguing that the application was not complete, therefore it is subject to what moratorium, and then of course it is subject to the SLUP that is now in place for private parks. Thank you.
Deborah, let me just jump in here a second, and if we don't do this on a regular basis. It's been a number of years since we've done this, so I have to depend on a little help from everybody. But I think the issue before us is what Ms. Blair has presented is an application for denial, the whole thing, because to dismiss simply because you didn't meet the deadline of January the 30th. So the issue of what took place with the private parks and the moratorium after that is kind of mute in my mind at this stage of the game. I gotta deal with the one issue that you just didn't file this timely enough.
Well, I mean, well, first of all, I did not. That particular date is not true, but it says on that it's a it says 30 days from the final decision, and I'm proposing that the final decision was made on April the 2nd, at the date that I had a meeting with Mr. Hosack and Mr. Peterson to discuss this.
But I think from the Board of Commissioners standpoint, and Deborah, correct me if I'm going in the right direction here, but the zoning issue was decided on December the 31st of 14, my understanding was the application was withdrawn. Is that correct?
No, I understand that.
Well, first of all, am I correct on that, Ms. Dance?
The appeal itself references the certification of zoning as being a basis for the appeal. If I can just interject, I mean, what I understand you saying is that what you're doing is attempting to say that you're appealing a decision actually made in a meeting with Mr. Hosack. Is that right?
No, I'm just saying that the final decision of the certificate of zoning took place at my meeting in April, because do we use the, when I've got, I mean, I carried forth with this thing. I understood this December 31st deadline. I understand that. You know, my contention is, you know, how do I know it's there? It's like it snuck through, so I wouldn't know it was there. So that's when I went to Commissioner Ott, and he actually told me that I had an appeal. So that's what I did, you know. And now all I can do is argue the fact that that was the final decision on this, and the appeal should stand.
Okay, can I open this up?
I have one question.
Excuse me. Deborah, can I open this up now
Sure.
for questions? All right, Ms. Williams has a question.
I don't really have a question for him because I don't think this is a time to question him. This is dismissal. This is a question for our attorney. In the meeting that he's referencing with Hosack and Peterson, was that advertised? Was that a public meeting? Did any other citizens know about that meeting?
You have no testimony before you other than what's been
Exactly.
presented
So
here.
it was just a private meeting. It was no public meeting at all, correct?
That would be my interpretation.
Thank you.
Any other questions before we proceed?
I have a question.
Ms. Swanson.
Can you, Ms. Dance, can you explain this process, the certificate of zoning issued, which was December 31st? Was this issued at the end of a public meeting?
Yes.
And this was approved? And then, can you please explain or read what a person in the community who wants to appeal, where is the language that gives them the information of how many days they have to appeal? Can you please,
I can.
because I haven't seen that.
Right. So Code Section 134-95 states, appeals to the board may be taken by any person aggrieved or by any officer, department, board, or bureau of the county affected by any decision of the administrative officer. Such appeal shall be taken within 30 days or as provided by the rules of the Board of Appeals by filing with the officer from whom the Board of Appeals is taken and with the Board of Appeals a notice of appeal specifying the grounds thereof.
Is there a notice or a form? How does a citizen like Mr. Proctor, how does he get that information if he doesn't know?
It's published in the
The code.
Cobb County Code.
So it would be, if he wanted
It's
to
a matter
file
of
an
public
appeal,
record, right.
he would have to go to the Cobb County Code to find the process of appeal?
Right, because those are the ordinances set forth for the governing the county, yes.
Okay, so it
Now-
isn't like on any form that when you want to file appeal, you go and fill a form and it has the information listed?
I don't know,
on
I
it?
imagine there probably are some internal forms that also convey the same information, but the official record would be the Cobb County Code. Also, as to the point as to the certification, what I think might be appropriate is you have an affidavit in the motion to dismiss from Mr. Peterson. You might refer to that as to information relative to the
What number is that?
certification of zoning.
That's the left side.
Okay. Mr. Gunther, do you have a question?
And if necessary, the board might want to call Mr. Peterson and clarify that process. I would not be the person to speak to it.
But you're saying, if I could just interject here, you're saying that the date of this decision is represented by the time at which it's published in the Cobb County Code, is that correct? I'm just trying to understand what you said.
Okay. What I'm saying about the Cobb County Code is the code contains the notice to the appellants here and to all citizens of Cobb
So-
as to the 30-day requirement for filing a notice of appeal. The date of the certification would be the date on which, my opinion would be, the clock would begin to run if the appeal is about the certification of zoning. The appeal is also about, in some respect or another, about the moratorium, which is initiated at a different date, which would be March 10th. So to me, there's two prongs on the appellant's documents.
Okay,
And you
I'm
need to
just,
look at each.
I'm just trying to understand, I understand December 31st, that's the date on the certificate. But when was that certificate first made public?
That certificate was issued to an individual.
Right,
It
so-
became at that point a public record.
But,
It
okay,
wasn't published in a
his
public
question,
meeting.
his statement is, how is he to know when something is issued so that the 30-day clock is starting to tick? And how is he to know, other than to know that, no, I'm just trying to understand.
Again, I think that the appropriate thing here would be to take testimony from a subject matter expert.
Okay.
That would be Mr. Peterson. I would suggest that the board might want to call Mr. Peterson and ask him these questions.
All right, Mr. Proctor, at this time, let's, if you would, just step aside. We'll call Mr. Peterson up to explain to us.
Explain the process. You can explain the process of how to get the certification.
All right, Mr. Peterson has been sworn in. If you would, Mr. Peterson, give us your name for the record, please.
Good afternoon. My name is John Peterson. I am the zoning division manager for Cobb County.
Mr. Peterson, I have a statement, sworn statement dated 14th of July of this past year. Would you tell us what's in that statement and how we got to the December 31st date?
Do you mean the July 14th of this year?
Yes.
What's in that packet, Mr. Chairman, are some documents that we produced in the zoning division. One of the documents is the West Cobb Sports Complex SLUP 19 paperwork from last year.
Okay.
There's also a staff recommendation in there. There's also a certification of zoning from myself dated December 31st, 2014. And I believe there's also an application for a clearing only permit dated February 24th, 2015. And all those should be attached as exhibits to my affidavit.
They are. I think specific question is, how did we get to the December 31st statement? How did we arrive at that?
What normally happens with a certification of zoning is that an individual or corporation will come to the zoning.
I tell you what might help. Let's go back to the zoning, when we went through the zoning. And I was not on the board at the time, but I think it was held at one period of time. Could you give us a little history there? Maybe that would help us all out.
The zoning was filed in August of 14
Okay?
to be heard as a October case.
Yes, sir.
In or about October, it was decided to hold the case for 2 months until the December hearing date, so the applicant could work with the neighbors and revise their plan if needed.
Okay.
During the pendency of the application, I was approached by the applicant for a certification of zoning, to certify what the property was zoned. And what the certification of zoning is, it's just a statement of fact about a property at a particular point in time. It's not an opinion about what I think it's zoned, it's what is actually zoned. So during the pendency of the application, I communicated with Mr. Varner, and I produced a certification of zoning at the end of December. The case was withdrawn from the Board of Commissioners hearing in December, at the beginning of December at the Planning Commission hearing. So it never got to the Board of Commissioners.
It was never voted on.
That's correct.
The case was withdrawn. The applicant withdrew the application.
It was withdrawn with prejudice.
Okay? And when you, the certification stated that the property was zoned R30, and under R30, such setbacks, building height, impervious surface, structure shall be subject to the rules of Cobb County and state agencies. That's correct.
That's correct.
Okay. So that's how we got to the December 31st date.
That's correct.
Can I ask a question?
Yes. Ms.
With the certification of zoning that you signed on December 31st, 2014, then does this become an immediate public document since this didn't go into the BOC because it was withdrawn? When did this become, like, how would I find this certification so that I could start a 30-day appeal?
Ms. Swanson, the certification of zoning are normally asked for by private citizens or corporations when they're trying to build something or buy something. And what this certification does, it gives lending institutions a peace of mind that what a person wants to use a property for can be used for within that government jurisdiction. So once I sign this and give it to the requester, then it's a public document and anyone can come look at it. Now, there's not a place where we keep these on the internet or at our office where someone can come in and just take a look at it. We do keep these on record in a binder, and anyone can come by and look at them at any time. But these are not public hearing documents, so they wouldn't be easy to find by someone just looking through the Cobb County website.
So it would be somebody that knows that this zoning case was gonna go to the BOC in December, and it would be then their responsibility to find all documentations related to this up to the point of the hearing.
That is correct.
Okay,
But again, this certification of zoning, it's not my opinion. It is the facts about the property. It's zoned this, and you can use it for this. That's all it
so
is.
it's just taking it straight out of code.
That's right.
So that raises my question. So there was no decision made on December 31st other than to just state the current conditions of that property?
That's correct. There was no zoning decision
The
made.
zoning decision was made sometime earlier than December 31st.
There was no zoning decision made. This property was
Well,
adopted already by the board.
I
in
know, but I mean,
1917.
at some point, it was zoned the way it was zoned, way back, years ago.
1972.
That's when the administrative decision was made, is that correct?
Well, that's when the board adopted the R80 zoning.
So there was no decision really made on December 31st.
That's correct. All this is a statement of fact.
Yeah.
Yeah, so, okay.
Let me kind of help clarify this. My experience with zoning is this. The reason they needed to come before the zoning board and the board of commissioners is they had a building in the middle of this complex that they wanted to use as a multipurpose building. Is that correct, John?
That's correct.
If they did not have the building, if the building was not in the application, under the 1972 zoning, they would automatically fall into a private park. Is that correct?
Private park is a permitted use by
Is a
right.
permitted use under the 1972 ruling.
That's right.
So essentially, the only reason they came before the board was because of the building, the complex building. they wanted to
20,000 square foot public nonprofit community center.
If they didn't have that building, they could have pulled permits and built a sports complex
That's
without
correct.
the building. Is that correct?
That's correct.
So that adds a little light to the whole thing, folks. Okay, any other questions for Mr. Peterson? I guess the question before this board at this time is, did the Mr. Proctor and his neighbors file this complaint timely? And I guess that's the first decision that we've got to make before we can proceed. Because before us right now, we have a case to dismiss that is backed up by the courts. Am I on the right direction, Ms. Stantz?
That's correct.
Okay. So, Ms. Williams?
I have a question. So the county's contention is that the clock started ticking on December the 31st as far as the timely thing of him filing the appeal.
That's what Mr. Peterson is saying.
Or if I might have Ms. Blair address that.
Ms. Blair will be fine.
That's right. The law states that when you file an appeal, it has to be within 30 days of the decision that you're appealing. So in this case, the appellants are appealing the certification of zoning, which is December 31st. So that starts the 30-day clock. And that's per our code and per the law, the 30 days. Did that answer your question?
Yes, it did.
Okay.
That's how you came up with the December the 31st. Since it was withdrawn from the Board of Commissioners, we didn't have a commission date, so we had to have a date, which would have been the day he certified the zoning, correct?
Right. Well, the appellants are saying that they disagree with the issuance of the certification of zoning, which, as John explained and Mr. Peterson explained, That's simply a factual statement of what is on the property. There is actually not a zoning decision that's being appealed here. There was not one
There was
made
not
at
made.
all.
Right.
So they're just appealing him,
Writing,
certifying what they
certifying.
do every day of the week in the zoning department.
Correct,
Okay.
correct.
So they're basically appealing the code that's written in our code book.
Well,
Because that's what the zoning, that's the certification of zoning, this is what our code says.
as I
on this
read
property.
their appeal, they feel that the certification of zoning is is not proper. However, it isn't an actual zoning decision, it's simply a statement that the zoning is R80 with permitted uses of a private park or or the recreational grounds.
And has been since 1972.
And could
I
I
mean, that's
ask
the
one more
important thing.
question? This was December 3rd. And when did they file their appeal?
Not until April 24th,
April the 24th.
right? Yeah,
So 180 days later,
yeah, almost 4 months.
4 months later. Okay. All right, thank you.
Let me, Mr. Peterson, I'd like you to come back up. John, my experience with the zoning board, this is not an unusual thing. You have, let me give you an example. You have many times, we have a fellow that wants to buy a house. The house is in a NAC, and it's an industrial compatible NAC. But but for all intents and purposes, the house is R20. Don't you write these things up for those types of situations too, that he could take to his lender and say, this is a house, I'm gonna buy it, even though it's in light industrial, but it's still an R20 house. Does this happen to you on a regular basis?
Mr. Chairman, I've been doing certification of zoning since I started working for Cobb County in 1998, and they're typically used for larger commercial type projects or institutional projects. You typically don't see them for one single-family house, but they're typically for large sums of money that a developer needs released from a financial institution.
Well, I bring up the one individual house because I had a fellow that worked for me at one time that was next to a convenience store, that was next to and he had that situation, and you were kind enough
Oh, that was by the bus barn?
by the bus barn, and you wrote it up to how he could get his money. That's the reason I brought that up. But my point is, you see these things all the time. I mean, this is not new to you, is that correct?
That's correct. It is not new to me. I've been dealing with these certifications since 1998.
Right. All right, again, any more questions for Mr.
I
Peterson?
have one. So you issued the certificate of zoning. This, what they are asking for to build, fits within this this zoning category. So then, on February 24th, when the clearing only permit application was filed, because you were just going through the normal process of them developing this piece of property, and that's part of the normal.
That's correct.
So when the clearing only permit application was filed, that's also something of record that a person who is opposing this complex could have gone and found this as well, that this application was
Oh, that's correct.
filed.
All right, other questions for Mr. Peterson? Deborah, do you have any comments you'd like to make at this time, Ms. Dance?
I would like to say that in fairness, I think that you ought to invite Mr. Proctor back, because it would appear that the basis of their appeal is not merely rest upon the certification of zoning issued, and you directed some questions to Ms. Blair about the appellant's intent. I think that you should hear directly from them on those points.
Okay, and with that, Mr. Proctor, if you would please come back up.
We're doing this on the fly with, just noted that, there's no code for the certificate of zoning in Cobb County, so, and it's not advertised. So, the certificate of zoning was not in the SLUP 19 folder as of December the 2nd, 22nd, 2014. This was filed after withdrawal.
I'm not sure I follow that. I'm not sure I
I don't
follow what you
understand
were
what you're
saying there,
talking
mister.
If I could I have another representative that's
Oh,
more
sure. Yeah,
familiar with this?
absolutely, sure.
Kelly, would you please come up here and entertain that, please?
If you would, for the record, give us your name.
Good afternoon, my name is Kelly Gambrill. There is currently no code in Cobb County's Code of Ordinance of how to obtain a certificate of zoning. There is no process, there is no documented procedure. Therefore, unless you knew that an applicant went in, there is no way you knew that he went in and obtained a certificate of zoning. If you were saying that Mr. Proctor's meeting on April 2nd was not advertised, the certificate of zoning was not advertised either. It is no different than a private meeting than what Mr. Proctor had on April 2nd. The certificate of zoning was not in the rezoning file as of December 2nd of 2014. We were carefully watching the file, we were carefully watching emails. It was not noted. Actually, the first time that I personally saw their certificate of zoning is when I looked at their site plans that were submitted when they originally, their first application was for a timber clearing permit, not a site plan clearing permit. And essentially, the permit changed 3 times from the original application on February 24th. Also, when the applicant filed his permit for clearing, he did not have all signatures of the 15 homeowners that also have claim to this parcel. That was noted to the applicant at the March 17th site plan review hearing when he was not given his permit to start clearing because it was incomplete. So therefore, the argument that he did not have a complete application for the permit on February 24th stands, because he did not have all signatures.
Now, but all we're discussing at this point is the December 31st. We're not into February or anything else there. We need to just stick with that one issue there.
Okay. Also, you stated this property was R30. It's not, it's R80. And then also, going back to the certificate was issued after December 2nd when the Planning Commission allowed the case to be withdrawn with prejudice. At that time, Planning Commissioner Bob Hovey made it very clear to the applicants that nothing could happen on this property. No sports complex could be built for at least a year due to the prejudice that was assigned to the property. So, everybody kind of took a breath and said, well, we've got a year to, follow this. And there was no reason for us to go back and check the file after December 2nd because for what we knew, this parcel for a sports complex was finished. Also, while the building might not be on the current site plan, it was just relabeled to infield training from the original building. So again, I know that is not what you're considering, but going forward from December 2nd to the 31st, that changed as well. But again, we were under no notice because we were told it was over.
Okay. You threw a couple wrinkles in there that made me think a little bit. Judy, do you have a question?
I do, Kelly. Kelly, the property is zoned R80. You've been working with this for years. Did you know that sports complex? Did you read what R80 allowed?
Yes, but if you read the purpose and the intent of the R80, it's residential and recreation. It is not a separate issue. There's also, and I'm sorry, I don't have the code in front of me, but there's a specific code, and maybe Bill can find it for me, that specifically says that commercial is anything that does not contain single-family residential, and that is in the Cobb County Code. Therefore, one could argue there are no residential homes that are gonna be constructed on this, therefore it is commercial. And that is one of the points that we were arguing during the SLUP process.
Yeah, that's.
No, that's
yeah.
still not.
It's section 50-216.
Yeah, I'll get to that.
Wait, this,
Yeah.
But Mrs. Williams was asking me if I knew that a sports complex could go into R80. And again, reading the purpose and intent of the R80 code, it says residential and recreation. But then if you go further into the code, section 50-216 specifically states that commercial development means any development which is not a single-family residential subdivision. Therefore, you could argue, you know, the certificate of zoning for the private park is moot because there is no residential on there. Another thing to argue is the code for R80 for recreation says that essentially you can have parking for the two adjacent subdivisions. He's got 850 parking spaces. That is not how many homes are in the two adjacent subdivisions to this sports complex, which then goes back and argues section 50-216 where it's commercial.
question was, you didn't know that recreation was allowed in R,
Not without residential.
but you didn't know that recreation was mentioned in the RA, correct?
In the code, but going back to the purpose and intent, it was with, we did not know it was allowed separately.
Okay, Kelly, thank you. At this time, I need to hear from Ms. Blair.
Just a couple of notes to Ms. Gambrell's comments. The certification of zoning procedure is listed online. So you can find out how to get a certification of zoning. It isn't online. Now, as Mr. Peterson said, it is not listed when it is completed, but there is a process available to obtain one of those. And I don't know, I assume that the timber clearing permit that Ms. Gambrell is referring to is February 24th. So she knew that there was a permit filed on February 24th, which would still have given them time to file a timely appeal if they so decided to do so. And they just didn't do it until April 24th. As to the purpose and intent of R80, and if you'll turn to Exhibit 5, which is Code Section 134-162 in 1. It's Exhibit 5, so it would be tab 5.
Open space, where are we now? Single?
We're,
Oh, before that, okay. Okay, R80.
the R80 district is established to provide locations for single-family residential uses or residentially compatible institutional and recreational uses. So it is not simply limited to a residential use.
Clearly states it.
And if you read R80 in the permitted uses, various, and let me get to some of those. As we're talking about, a sports complex is not solely a residential use, but it is indeed a permitted use in R80. So while they do have to have something to do with residential, it's residentially compatible and not simply and solely limited to residential. And unless you have some questions of me, those were my comments.
I have a question. Where does it state in the code that Ms. Gambell
Granville.
brought up with parking? The parking.
The parking,
Where is that stated within the code regards to, so if we go with the fact that this can be placed in R80, and it doesn't have any attachment here as far as having to build a subdivision, where does it state that it has to be
What,
the number of parking, those with the surrounding
what Ms.
subdivisions?
Gambrell is referring to, I believe, is if you now flip to tab number 7, which is section 134-193. And we're going to go about halfway through to letter E. And this is just in the code section. It's entitled Neighborhood Recreation Centers, Amenities, and Swimming Pools are subject to the following.
Oh, wait a minute. Let's get back to
Yeah.
page 7,
Tab 7,
E.
and it's 1, 2, 3, 4, 5, 6, 7. It's the 8th page of section 193. And it says E, Neighborhood Recreation Centers.
It's the 8th page, yeah.
Sorry, I didn't have that further tabbed. I didn't know we were.
Keep going, go ahead.
Is it the second to the last page?
Keep going.
No, it's page 8 in section, are you all on tab
We're
7,
getting
which
there.
is section
Listen,
1?
You got it.
Okay.
It's right here.
Ms. Swanson, did you?
I'm counting 8.
Kim, it's, got to go down. Got to keep going.
You're 7, right?
Just give us a minute.
Okay.
Let's look at this.
Okay, sorry.
So what does this mean? Do you want to interpret this for us?
Well, this whole section, E, deals with neighborhood recreation centers, amenities, and swimming pools, which are part of a subdivision. That doesn't mean that these regulations relate to any residentially compatible use. When you have a subdivision that has the amenities, the clubhouse, those kinds of things, the pools, then these things apply. It's not across the board. They don't have to apply to, if we look at permitted uses, which is number 3, permitted uses are designated recycling collection locations, golf courses, group homes, non-profiting fishing lakes,
Page 3 of section.
private parks, parking for vehicles. Those do not have to comply with section E. The section E relates solely to
Okay.
amenities as part of a subdivision.
So then to, no, my other, so then, when it comes to this entity that wants to go into this space, then these don't apply. It's only when an entity would have, along with it, a subdivision. Is that correct? This is a standard.
Right,
So
right.
what
A
are the parking?
neighborhood recreation
Right.
center is like your clubhouse, your
So
HOA
this, what's
operates.
going in there is not a neighborhood recreation center.
Right. What's going in there is a sports complex,
Right.
a private park. It's not going to be residential. There's not going to be anybody living on it. But that's allowed per the code because it's
Right.
residentially compatible.
I understand.
So-
So where though on these private parks, what are the parking requirements that they are talking about? Because 850 seems to be quite a number of parking. So where is the code on how you determine parking, given this entity going in there?
That's a different
All
code.
right, you know what?
But
I'm just-
before we
you're
go on
just
there, I have a
going
question.
through the things that were discussed.
All right, wait a minute. The issue, there's only one issue for us. We're getting into the parking, we're getting into a whole lot of stuff. The only issue there is it a timely manner? At this point, was it a timely manner?
And I just want to ask a question.
Follow up with a
Okay.
question.
So, the assertion was made that it needs to, if R80 needs to include both residential and it can include recreation if it has residential as well. But by reading the purpose and intent here that you brought us to in the code, there's an or in there. Very clearly, it's an or, it's not an and.
Correct.
So, working backwards, the implication were at and, if the word and were in here, the implication would be that the certificate of zoning was incorrect. But that implication is not correct. The certificate of zoning is a statement of fact. There's nothing wrong with it. It's correct. It's just a statement of fact. It has nothing to do with mixing residential and anything else.
You're correct.
Yeah,
correct,
okay,
yeah,
so
yeah.
I just wanted to make that point.
Okay.
And again, the issue is in a timely manner. What Mr. Peterson has acknowledged to is that under the R80 zoning, this is an acceptable use, has been an acceptable use since 1972. He did this on December 31st, and they did not comply, in my opinion, at this time, did not comply within the 30 days under state case law. Now, I'd like to get Mr. Proctor. Do we have any more questions for Ms. Blair?
I neglected to write down the first meeting that Mr. Proctor had with Hosack and Peterson. What was the date on that? I'm sorry.
Second.
April 2nd.
April the
2nd.
2nd. Okay. Thank you.
Okay, Mr. Proctor, I'd like you to come back up, and your cohort has raised his hand. If he has anything to say, he's welcome to come up with you. I tell you, where my heart kind of goes out to you, you've indicated that you had a discussion with Mr. Ott.
I did.
And rightfully so. Mr. Ott answered your questions and was kind enough to talk to you. Problem is, and this is only a determination and an idea on my part, he evidently gave you the wrong advice, in my opinion, from what I'm hearing so far. And I feel sorry about that. But the issue that we've got to deal with before we get into the other stuff is it timely or not? And I've got to get over that before I can get into everything else.
Hey, I understand that.
Yeah.
I do.
Yeah.
I'm as frustrated as I can be because trying to find out any information, it's from the planning department. I mean, I was on this thing from the start. I've been doing this since last October.
Yes, sir.
And then for this thing to sort of all of a sudden slip in with no notice and I have no right, and I wrote emails to people concerning all this, and everybody put their head in the sand. And Bob Ott is the only person that came out and said, I'll meet with you. And when he did, he told me I could appeal. So I said, well, at least I have a voice. Obviously, that isn't true because I missed the deadline, and I could argue plenty of other things on here, but it isn't the place or time.
I think.
I almost have to say something because I am really the thing that the residentially compatible that people keep talking about and saying this project is residentially compatible. It isn't.
Well, that might be a whole new issue.
Oh, I believe me. I understand.
And that's a different issue, and
I know.
I'm trying to stay away from that issue for the time being.
I know. I understand. I
'Cause
do. But
you-
other folks were talking about it, so I had to put my 2 cents worth in.
There might be an argument there.
Okay.
Sir, come on up.
Thank you.
Executive session. This thing has gotten out of hand. We should be just talking about the dismissal. You can't get it.
See what he has to say.
All right, sir, if you would, give us your name, please.
My name is Jerry Kelly.
Tell us what you want to tell us.
1881 Villa Rica Road. I've been there going on 31 years. I built this home for my retirement and my children's future, my grandchildren and my great-grandchildren. My property line is from this podium to y'all's dias up there. So this facility, if it goes in, will be 7 day a week till 11 o'clock at night. My house faces south, floor to ceiling windows. It faces directly to the Varner property. I can see every move they make over there almost. And if you can tell me how the lights and the noise and the hubbub won't destroy my home, destroy the value, and quite frankly, it may destroy me before it's over with. I'm probably the oldest person in this room. When I bought my property, John Varner was 15 years old, I think, not 1981, and I built in 85. So, y'all look like reasonable people. I'm trying to address your reasoning on this issue. So I'm pleading.
Yeah.
I suggest you should read OCGA Official Code of Georgia 41-1-1. That's the first part of the code. There's several others that covers the issues that I will be involved in.
Mr. Kelly, I don't disagree with you. I think there are other issues out there. Again, at this point in time, I'm only faced with the one issue that I've got to deal with today, that I've got to deal with right now. I do understand there could be other issues out there. Both you and Mr. Blair have brought those things up, but at this point, I only have the one issue to deal with, and that's a timely matter, and that's what I'm faced with.
Well, it's not appropriate for our low-density area, number one.
I'm not going to go there.
Some of the other people stated that, I think.
Yeah.
It's just not.
All right,
It's a
anything else?
commercial enterprise.
Would this be
Anything
appropriate
that
at
brings
this
in
time
the
to ask for
public
a
in general is a
executive
commercial enterprise for
session?
profit. So I won't take any more of your time. Thanks for listening.
Thank you, Mr. Kelly. I appreciate it.
I would like to
Miss,
ask the officer for an
Deborah,
executive session.
this board is asked, or there's numerous people jumping in here, but they'd like to go in an executive session. Would that be appropriate to do now?
To consult with legal counsel?
To consult with legal counsel, yes.
That'd be appropriate upon a motion and vote to do so.
Okay.
I make a
all right.
motion that we adjourn for a executive session with our county attorney.
Okay, I've got a motion by Ms. Williams. I have a second by Ms. Swanson. All those in favor signify by saying aye. Aye. Any opposed?
Where do we go?
Ladies and gentlemen, we're going to take a little 10-minute break, and we're going to go in that cubbyhole over there.
Okay.
Everybody else just sit tight. We're going to confer with our county representative of the attorney's office. Okay, ladies and gentlemen, we're back from our consultation, and today is the Cobb County Board of Zoning Appeals. We are listening to this particular case, and we have taken a brief time to confer with our legal counsel, and I'm going to turn it over to board members for any comments, or if we're ready to make a motion. Ms. Williams?
I think that in listening to the testimony, I think the whole thing boils down to that there really is no specific time that we're talking about, because zoning certification letters are issued every day of the week, and if everybody was going to appeal every certification, then we'd be awful busy in the courtroom. So my feeling is that they did not meet it. They have nothing to meet. They did not meet filing in a timely manner, and they had plenty of time to do it, so.
Kim, you want to make a comment?
After meeting with our legal counsel, and we're looking specifically at this dismissal based upon filing in a timely manner after the Mr. Peterson gave the certificate of zoning, just that alone is what we need to look at. And so, based upon that, the 30 days was not met when they filed the appeal. So I think we need to just focus on that and not focus in on all the other issues that come about. And Mr. Peterson was correct in filing that, and it just was the 30 days then ticked from there on the, but I don't have the information up here, but from the 30th.
Okay. Skip?
Yeah, I'm ready to make a motion.
Okay.
I guess one of my questions was that certificate of zoning accurate? Because of the discussion about the words, the use of the word or and I think we established that it's or. And in fact, I note in the filing that the plaintiffs have made, that it was misquoted slightly. It said, I just looked at it, it didn't use the word or, it used the word of. So that was a little bit, it was probably a typo, but it made it difficult to understand. In any event, I'm convinced that it was an accurate statement of fact, that it's zoned R80, and parks, our private parks are an allowed use, so there was nothing about that. That status was established well before December 31st, so there's any complaint filed in April is well outside any 30-day window. So I make a motion that that this appeal be dismissed.
Okay, I have a motion. Do I have a second? Second. Any other further comments? Just by way of a comment, it's kind of sad that we didn't get into the merits of the case. I think we were all anxious to get into that. At this particular time, we were faced with the regulatory procedure inserted by case law that we've heard, so we can't get into that. There is another appeal. You can go across the street to the Superior Court. There's other things that can be done. Once the application was withdrawn and the building was taken out, I think under the zoning started in Cobb County in 1972. And based on that 1972 zoning, I think Mr. Peterson made the right decision at that time. So I've got a motion, I've got a second. No other comments, call for the vote. All in favor, signify by saying aye. Aye, any opposed? Madam Secretary, we're going to dismiss this particular case with a 4-0 vote. Ladies and gentlemen, I'd like to thank you all for being here today and hope you enjoy the rest of your day.